Good evening, everybody. I hope you are all doing well. Today is, what is today? April 9th, 2025, and I hope where you are, the weather is moderating. I'm in Atlanta, and we had a very nice day today. It was probably about maybe low 70s. Nice to be outside. Took a nice walk. It was very good. I think tomorrow's supposed to be a little cooler and rain. That's what you're going to get this time of year. So I hope that wherever you're at, you're doing well as well. All right, so we'll go into our normal questions and answers like we always do. We have a question here. I don't see too many questions right now, so we'll see. If not, I've got some things I can tell you about. Blue Z, there we got a couple more people. Blue Z says, it's been 6 weeks since my hearing. I haven't heard a peep yet. Don't know how long I'm going to wait before I start calling on it. I would tell you that right now, on average, what judges are telling my clients is 4 to 8 weeks. What's actually happening behind the scenes is Social Security, when a judge hears a case, his or her notes become part of a file. That file then goes to a decision writer who's going to be in a different state. In fact, I think I've mentioned this before. One of my former paralegals became a decision writer, went to law school, became a decision writer. That has to be written up, has to go back to the judge for approval, then released. Obviously, there's a lot of things going on at Social Security personnel-wise. A lot of people kind of in middle management that, were doing different tasks. Those people have been being reassigned or taking buyouts. So I suspect that things will be taking longer. One of the things, for example, I'm telling people when they contact me about potentially filing a case is, the delays are not going to get better. They're going to get worse. So if you're going to do this, go ahead and start the process now, while people are still there, and, get the process going, because it's not going to get faster. So definitely want to, if you're thinking about that this may be something you want to do, I would tell you not to delay on it. So, but to answer Blue Z's question, you can call, but the problem is who you're going to call. You call the 800 number, you'll be on hold for 3 hours and then disconnected. You can call the OHO, the hearing office. They're not going to be able to tell you anything. I would tell you at this point, when it gets beyond 8 weeks, maybe even 10 weeks, then maybe, start making some noise. But I mean, that's going to be the norm. I think that, 4 to 8 weeks is pretty typical. I've got a bunch of cases that I tried the last couple of months, and I'm just sitting there waiting for decisions. Sometimes decisions will come in fairly quickly, sometimes not. It just depends on how busy the writers are. So, but I would tell you it's not you. And there's no correlation between the amount of time it takes for a decision to be issued and whether it's going to be approved or not. It's just they're backed up. They're losing people. They don't have enough people. And that's not going to change anytime soon. So that's what I would tell you on that. Thomas Lee says, Thomas, I'm looking here. It says, I can't see what I can't really see what your little icon says there. It says, but good evening to you. Janelle, do vocational experts typically ask judge questions only to clarify something? In other words, the vocational witness is there to answer questions. And sometimes what judges do, and as you probably know with vocational witnesses, these are people that have knowledge about different types of jobs and what employers will tolerate. And so what judges do is they create these hypothetical questions, and sometimes they can be very detailed. I had one the other day, just earlier this, I think it was, I had 4 hearings on Monday and 1 on Tuesday. So it's all kind of run together. But I had one judge who had this, obviously prepared it ahead of time, this long question: assume an individual limited to light work, no climbing ladders, ropes, and scaffolds, no, bending, kneeling, crouching, no overhead reaching with the right upper extremity, no foot controls, needs to avoid being in temperature extremes or around dust, fumes, and gases, and on and on and on. And then the vocational witness wanted to get clarification because the judge went through this really, really quickly, and the vocational witnesses do not have this ahead of time. So sometimes a VE will say to the judge, can you repeat the question, the part about, no climbing ladders, ropes, and scaffolds, or no bending, kneeling or stooping. So, you may get some of that, but generally speaking, the vocational witnesses are to answer questions. The other thing is judges now ask vocational witnesses a lot more questions about their sources and where they came up with things. It used to be vocational witnesses would use this resource called the Dictionary of Occupational Titles. The problem is the DOT was last updated in the early 90s. And some of the jobs in it, if you look at it, go to occupationalinfo.org, some of the jobs described in the DOT were last updated in the 70s or 80s. So it's way outdated. And, vocational witnesses can't rely just on that. There was a case that came down where a judge got reversed because the vocational witness was not able to explain where he or she came up with some of these job numbers. And so there are other resources out there that the Department of Labor and other entities put out. There's a computer program, I can't remember the name of it, but there's a computer program that a lot of these vocational witnesses use. The problem is that the DOT, which is individual codes for different jobs. So let's say a laundry marker would be one code in the DOT, and a small parts assembler might be something that would be a different number. Some of the codes that the Department of Labor has put out, there may be multiple DOT codes within one of these other codes. Again, it gets very confusing, but the point is that we honestly don't know how many jobs really exist for some of these occupations. And so the vocational witnesses are really estimating. One of my cases this week, the vocational witness says, well, there are 10 DOT codes within this one occupational characteristics code that's more current. And so I just took the number of jobs in this SOC code and divided by 10. Well, that's ridiculous, because what happens if in fact 2/3 of the jobs in that SOC code are one DOT code. And so you may have jobs that really don't exist. I had a vocational witness in a case this week, which I think will be approved. She identified 95 jobs, that exist within this one DOT code. Well, I'm sorry, that's not a substantial number. If you look at that nationally, it's like 2 jobs per state. Well, that's not sufficient. So, judges are asking these questions, and the vocational witnesses are answering with varying degrees of efficiency. But you can, that would be grounds for appeal if this judge denies my case on the grounds that there are 2 jobs that exist, in the economy, in a particular state that a person can do. Well, that's not sufficient numbers. You've got to show jobs that exist in sufficient numbers. So there's a lot of debate going on amongst lawyers about how to go after vocational witnesses. I think Social Security, it seems to be satisfied if the VE, vocational expert, can come up with some sort of methodology. But I will tell you, having listened to a bunch of VEs testify recently, some of them are really on it as far as their methodology. Others are just like, they come up with one thing that I think would be appealable. Now, again, the cases that I've had this on are cases that will be approved, I believe. But if they're not approved, I'm going to object on the grounds that the VE testimony was not sufficient to show the jobs exist in sufficient numbers. So the point is that VEs will ask judge for clarification, but generally speaking, the VE is not going to be asking questions of the judge other than to get clarification. And I gave you a long-winded answer for something, but I just want you to be aware that VE testimony is an area that many attorneys see as being ripe to attack the VEs and to appeal. I see it for appealing. I've never been one that likes to really attack a VE unless their methodology is so totally ridiculous that you have no choice but to do it. And you're losing. In other words, if I'm winning my case, I'm not going to make a big deal about it because I know I'm going to win. But if it's not going my way, then I might be more aggressive that way. All right, Trish Wade. Hello, Trish Wade. Deb is here. I think, Deb, I think you said you were in Iowa, someplace in the Midwest, but I'm glad to see you. Deb always has some very interesting observations and thoughts about some of the questions that people are asking, which is always very, very helpful. Appreciate that, Deb. KU Thunder, KU Thunder. I'm guessing that would be Kansas University Thunder. I don't know why I thought it was something else. I actually had a paralegal at one point years ago named William Koo. So I'm like, see KU Thunder. I'm like, it's probably his last name. I realized I see the little icon on the YouTube name, and it's obviously KU Thunder. So this is obviously Kansas University Thunder. Good evening to you. Denise, my appeal has been returned back to the hearing judge. They said the judge didn't get my evidence. What will happen next? So now Janelle says, my lawyer. So the vocational expert asked a question that may or may not be answered. The judge will decide and answer how long after the judge decides do you get a decision. So, I mean, I'm guessing that you got the appeals council or district court to remand the case. That's what they call it. They send the case back to the judge for additional development. The judge asks additional questions of the vocational witness, either by interrogatory, which is written, or by a supplemental hearing, and then the judge will issue a decision. And as people say to me, well, if the judge gets slapped down by the appeals council, does that mean the judge is going to be more likely to approve? Maybe some yes, maybe some no, but I still would give you, as far as the time frame, anywhere from 4 to 10 weeks to get a decision. I think is probably pretty accurate. That's just the reality of what we're dealing with right now. Teresa Bond, I have a telehealth meeting scheduled and a medical appointment coming up, both within the next 2 weeks. Any advice on what to expect and how long for these appointments for decision? So I'm assuming, Teresa, these are consultative evaluations with Social Security doctors. The telehealth, I'm guessing, is a psychological consultative, and a medical would be an in-person. What's going on is that the adjudicator, the claims specialist, has sent you out for these evaluations. They are part of the medical development. At the same time they're sending you out, the adjudicator is also developing the record, requesting medical records. Excuse me. And when the report comes in from the consultative doctor, that is part of the file. If other records are already in there, the file will be marked as basically complete. It'll be sent to a medical specialist that works with Social Security. These are independent contractors that will review the file and then make a recommendation back to the adjudicator. That process can take anywhere from 2 weeks to 3 or 4 months. It just depends on how well the case is developed. I mean, adjudicators, what they're doing is they're requesting medical records. Sometimes they get them all back pretty quickly. Other times they got to make 2 or 3 requests. And sometimes you have an adjudicator who will take a special interest in your case, that this person believes that you should be approved, and is trying to put together the evidence to support an approval. So there is no definitive time frame. Normally the report from the consultative doctor will be back in the file within about a week of you going to the doctor. If you have an attorney at the early stage, then the attorney can log in to your electronics file and get a copy of that report for you to see. But otherwise, you just have to wait for the adjudicator to complete the file. So that's what you're waiting for, is the adjudicator to complete the file. Again, it can be a few weeks, it can be a few months, and it's not like a broken record. But with all the turmoil going on, the people that have taken early buyouts, the new people that have come in that were doing middle management and now are being asked to do field office work, it's going to be a little chaotic for a while. There's a blog I read. Charles Hall is an attorney, I think in North Carolina, and he does a blog, and he's constantly posting. Needless to say, he's not a big fan of what's going on now. And he was talking in his blog, and he had some reports from some of the middle management people at Social Security that were doing who knows what in executive offices are now being reassigned to field offices. And they're being asked to develop medical records, answer phone calls. And some of them are like, well, we'll do what we have to do. We want to do a good job. Others are, it's going to take us a long time to get properly trained. There's some people in the Social Security Administration who are saying to ask someone who's been doing, data analysis or analytics to come in and develop a medical record. They've never done it before. That is a completely new task. So, again, we don't know. I mean, obviously one of the things we do know is going on is they're trying to reduce the workforce, ostensibly to get rid of people who are, kind of at this analytics level, who are, doing things that are creating reports and preparing for meetings, but not really doing any substantive work. Whether or not those people are essential to the mission of Social Security or the disability part of Social Security, beyond, I can't really say. but certainly having more people in the field doing substantive work, developing medical records, organizing files, getting cases ready to be processed, that's a good thing. So I know that seems to be some of the effort that's been going on, and I hope that does actually occur. But as in anything else, if you've not done a particular job and you're moved from one role to something else, whatever that case may be, you're a hospital administrator, and now you're moved to you know working up lab reports or something. I mean, it's a very different type of job, and so there will be some hiccups along the way. And then, of course, we don't know how many people are going to leave, so there may be a lack of experienced people. We're already seeing. I had a couple of cases. In fact, there's one gentleman who is on our live stream quite frequently. We got a denial notice back, and the denial notice came in, I think, yesterday or today, and it said, "Well, we're denying this because you didn't return this form." Well, I have proof they got it. I mean, we sent it in. It's the same form of medical authorization. We sent it with everything. I have proof they got it. Obviously, somebody who doesn't know what they're doing didn't know what to look for, didn't know where to find it. It wasn't there. I had a hearing this week where my appointment of representative forms and fee agreement were not part of the exhibit file. They were in the unexhibited part of the file. The problem is, if we don't get it in the right place, the judge is going to approve the case but deny my fee agreement because the fee agreement's not where it needs to be. Just stuff like that is going on, and it's really more inexperience or overwork. But these are the sort of things that we have to really watch out for. And as an attorney in this area, this is the sort of stuff that we're going to be doing a lot more of. My staff and I, we're really watching what's going on, and this nonsense of denying a case because they're saying we didn't send a form in that we know we sent in, and we can prove we sent it in. We have the receipt because we file them electronically. That's one of the things that I do is I file things electronically. I get a confirmation number, so I can prove that it came in. It's one of these things, though, that we're going to see a lot more of these nonsense, administrative denials because the people that are looking at it were either overworked or didn't know where to look. And so, we're going to have to jump in and save keep the case active. So, that's going to be more what my staff is going to be doing. And again, I think that, when people say, should I get a lawyer early on? Do what you want. I'm just telling you, that's one of the things that we will be doing more of. And if you choose not to do it with a lawyer, you need to really watch what's going on. Because I think that, some of these, very, very sloppy, I'll call it sloppy to be nice about it, errors are happening. We're going to make sure that we keep things on track. And, I'd say probably 80% of the time won't have a problem, but those 15, 20%, we got to jump in and say, wait a minute, this is not right. So that's what's happening. Joe Minnick, I have MS. I had an MRI before and after I got approved. How much do I worry are they reviewing your case right now? I'm not sure if you say they are reviewing your case right now or not. I mean, with MS and you have an MRI that shows a lesion on your spinal cord or your brain, generally speaking, those lesions don't shrink. And if the symptoms and most MS, not all, but most MS, the way it progresses is you'll be kind of plateaued for a while, and then you may have a period of time where your functioning declines by 10 or 15%, and you have a new plateau. And, the medications are designed to keep you at that plateau, but, eventually you may go lower, a different plateau. I had a case recently, an MS case, where that wasn't the type. It was basically my client sort of plateaued. There was no new lesions, and basically he's just kind of on an ongoing plateau. And, fortunately for him, the medications were keeping it fairly stable. I think he still has enough to win, but, not always are relapsing, remitting type of MS. So I think one thing, Joe, is you need to find out what type of MS you have. Is it one where you're likely to have these, reductions in functioning and then new plateaus? How effective is the medication? And of course, in a continuing review, do you have medical support from your doctor that says that your functioning has not improved? And I think Social Security recognizes that MS generally is not a condition where your functioning will improve. Ideally it stays the same. It doesn't get worse. But, what you got to be careful about, I would say, is if they send you one of these continuing review forms, you want to respond to it. Because where I've seen people get in trouble is they don't respond on time, or it gets lost, gets to the wrong place. Then they say, well, you didn't respond to it, and they move to cut you off. And then you got to undo all that. Again, this is another area where, because the staffing is a little suspect at times, that can happen. I've seen that happen before, just like, again, in my cases where they will deny something administratively saying that they didn't get a form when we know they got the form. So, if you can, what I would almost tell people to do is, if you have a continuing review, send your response in 2 or 3 ways. Mail it in, fax it in. If you can do it electronically, do that. Get it in and send it return receipt requested so you can prove that it went in, because I think we're just going to see more and more of that kind of nonsense. So just be aware of that. But I think that with MS, again, you don't say how old you are. If you're late 40s, early 50s, I don't think, you're going to have too much of an issue. I don't see those cases as being likely to be reviewed and moved for termination. Russell says, what are your thoughts on folks getting a little taste in our checks regarding Doge? I don't understand, Russell, what you mean by that. A little taste in our checks. I'm sorry, Russell. If you could rephrase that? I just don't know what you're asking me. Teresa, the telehealth is mental health. Teresa said she's got a telehealth mental schedule and a medical appointment. So the mental status telehealth, which means basically that you'll get a phone call from a psychologist who will do an exam either by video. I assume telehealth is going to be done by video, like a Zoom type of call, where they'll ask you questions. And, mental health consultatives actually do okay. They lend themselves okay to telehealth. And what actually happens in a telehealth or a mental health exam is there's certain tests that you'll be given. For example, the doctor will say, I'm going to give you 3 words to remember, or 5 words. And then 10 minutes later, they'll say, what can you remember? Or they'll ask you to spell certain words backwards or count backwards by 7s. There's just a series of tests. Some of this is to determine whether or not you are being truthful, because people that, answer, let's say they can't count backwards from 7, but they are able to remember 5 words, from 15 minutes ago. That's not consistent. Some of these are designed to determine if somebody is, exaggerating or have what they call secondary gain. Others are to determine whether you have deficits in your memory. So, there's a number of different tests based on the questions. They'll ask you for a history. They'll ask you about, your sleeping patterns. Do you feel depressed? Things like that. And they will draw conclusions about it. And a good psychologist typically has done this enough where they can kind of get a sense of, do you have limitations? My experience generally, not always, but generally has been that psychological consultatives are fairly useful, that the doctors, the psychologists that see you are basically people that do treat regular patients, just making sure nobody's, okay. They do treat people, regular patients, so they're not looking for a reason to turn you down, whereas the physical consultative evaluations, many times those people are, insurance company doctors that are looking for reasons to minimize what's going on. And so what you've got is the medical exam, which is basically x-rays. If you've got some physical issues, they'll take x-rays, which quite frankly are probably one of the least effective diagnostic tools for many orthopedic problems. Really, MRIs are much better for any sort of disc issues, things like that. An x-ray will show a broken bone or maybe some bone on bone in joints, things like that. Or if you've got rheumatoid arthritis, it may show swelling. So I wouldn't rely on that to win your case. I wouldn't rely on a psych consult or a medical consult. You've got to go through with them, but your own doctors are going to be a lot more valuable. But you got to go through with them. But, I would not fear the telehealth. Just tell the truth to the psychologist and, try to get a copy of the record. I would definitely tell you that to write down everything you can remember about what happened at that telehealth meeting, so that, down the road, you or your attorney needs to attack the legitimacy of it. You can referred to real-time notes as to what actually happened. All right. So Deb Lindley is responding to Denise, talking about the appeal has been returned to the judge. And the judge did, I think what Denise was saying was that there was some evidence that was maybe available to the judge that was not considered. And now the appeals council has said, Judge, you have to consider this evidence. It was properly submitted, or it exists, or it's relevant. I mean, realize they want to get things right. I mean, believe it or not, I think most Social Security judges want to get things right. And they have all these rules about submission of evidence. If you don't get it in on time, within 5 days of a hearing, they're not going to consider it. Some judges are real sticklers to that, where, if the evidence is not there, they won't consider it. But, a lot of judges want to get it right. So if there was an MRI report, let's say, that would be very relevant and it didn't get in time, are they going to really punish you for that? Especially if it was maybe your lawyer's fault or you couldn't get it. Sometimes you can't get it in time. I think as long as it's not, a pattern by the lawyer, as long as it's not something where it looks like you were just not cooperating, I think a lot of judges, in my experience, are open to receiving late filed evidence if it is especially relevant. If it's not particularly relevant, maybe not. Again, some judges are like, I don't care. It wasn't in within 5 days. Screw you. But, I think if I was a judge, let's put it this way, if I was a judge, I would not be very happy about getting 500 pages of records in 2 days before a hearing. However, if I got in 10 pages of updated records from an orthopedist with an MRI report, I would look at that. So it's just a judgment call. And again, some judges are just going to be real hard line about it. Others are not. But it looks like, for whatever reason, the appeals council sent this case back, Denise's case back to the ALJ for further review. Or perhaps the appeals council told the judge to send her out for a consultative evaluation, or maybe with an objective test like an X-ray or MRI, because that's what was needed. Again, the big picture here is that ideally they want to get it right, as opposed to denying somebody on a procedure. At least I would hope that's the case. All right, Balad 2001 says good evening to you, and Denise says thank you to Deb. And for your process, yeah, it can take a long time. Lucy, do they ever send out investigators to determine the outcome? Rarely. I mean, Social Security does have an Office of Inspector General, and in 30-something years of doing this, I can recall a couple of times where investigators were sent out. One of them was a case that I had tried. Case was approved. My client was, he had done work in a field. He was an employee of the federal government. I'll just leave it at that, where he had taken it upon himself, he and some family members, to write a blog that, or maintain a blog that was very critical of his former coworkers. And his coworkers were not very happy about this. And so, there were posts on the blog sort of contemporaneous with his disability claim being processed. And somebody obviously knew that he was been approved somehow. It's not public record, but they obviously found out. But they also knew that there were some recent posts on this guy's blog. That person, the upset former coworker, sent a letter to the Inspector General saying, this guy says he's disabled, he can't do anything, but he's posting on a blog, he's speaking, he's doing all these things. My client claims it was not him, it was done under his name by his brother. But anyway, the Inspector General came out and they did an inspection of it. They looked at the blog, they followed him around, and they ended up sending it back to the judge, and it was reversed. And so his case, he got reversed because he was doing things he should not have been doing. Again, he was being very outspoken about something that, made him not very popular, not a particularly smart thing to do. Maybe he was telling me the truth. Maybe he wasn't. I don't know. But he ended up not getting his benefits because of that. So the point is that if there are people out there who know you're in the middle of going through the disability process and who have a grudge against you, or you have people maybe that politically disagree with you and feel like, everybody filing for disability is faking it and they know you're going for it, could you find a troublemaker? There are nosy neighbors. There are, troublemakers out there. That's why I tell people, it's nobody's business what you're doing. And the fact of the matter is, in disability matters, especially mental health cases, or even some physical cases, you may look perfectly normal, whatever that means. But you may have some serious medical or mental health issues. It's nobody's business. And, nobody should be questioning you. A judge has made a decision. It's really hard to win. And, being on disability doesn't mean you can't go to the grocery store, that you can't drive, you can't go watch your kids or your grandkids' soccer game. You just, if you're claiming disability and a back injury, you don't want to be out there in public. You shouldn't be anyway, theoretically, lifting heavy bags of groceries and carrying them in, or, climbing, cleaning your roof, or riding a motorcycle, things like that, which again, a disinterested third party might say this looks a little strange. This doesn't smell right. So, use common sense. And at the end of the day, you got to tell the truth. I mean, I think that one of the things going on now is there's a perception that many people pursuing disability are not honest about it. I happen to think that's not true. I think most people that I see, this is really, they have no choice. But, there are people out there who, have they feel like it's their life's mission to attack the Social Security disability system. So I would just say, be aware of that. Answer your question, Bluesy. Yes, they do send investigators. Big picture is, I think it's just best to keep low profile, just in general, because it's nobody's business. Teresa, thank you. Oh, my pleasure. Yes, it is a very, very frustrating process, tasking process, what you call it. And yeah, it's just, the more you know, the more prepared you're going to be. The more you know about the questions you're going to be asked. In fact, I just did a video today about work history and how important it is. And I'll tell you kind of what the video is about. Is, every hearing after going through preliminary matters, judges ask claimants about their work history, what they did, who they worked for, over the last 5 years. And it's the first thing that really you testify about. And it occurred to me, again, after doing all these hearings the last couple of days, I mean, look, 9 hearings in 3 days, that you can really start everything off right. You can start to make a really nice impression. You can establish your credibility by being very clear, concise, and accurate when talking about your past work. You should never be thinking about it for the first time at the hearing, but B, you should know you're going to be asked about who you work for, what you did, and what the requirements of it were physically and mentally. So, how much did you lift frequently? How much did you lift on occasion? Were you having to focus and concentrate? Were you supervising? Were you scheduling? I mean, all these different things that, I go over with my clients. And so I'm now going to tell people, just write some of this stuff down. It's going to be asked. And if you can kind of zip through that, where you're very, very clear, very, precise about it, you're very matter of fact about it, you're sending a message to the judge. I'm going to tell you the truth, and you can believe me because I'm telling you the truth about this stuff, which you can see. I'm going to tell you the truth about other things. So my point with the video was that, and you'll see it when it comes out, hopefully next few weeks or months or whatever. But make a good impression with questions that you're going to get. So part of what I want to do with this live stream, with my videos, with everything I do in terms of educating people about this process is, if you can get a little bit of an edge, 5% edge, 3% edge, that can make the difference, because there are a lot of cases that are really close. And, if a judge is going to, find that you're more believable than the next guy, you may be, even a judge with a low approval rate, you may be one of the ones that gets approved. I mean, my feeling is that, any judge who's approving at over 40% currently, is pretty reasonable. I mean, the average is about 48, 49%, just by numbers that, a judge could have a series of cases that aren't that strong. They're at 40%, 43%, you're going to get pretty likely going to get a fair hearing. You get judges 35%, 30%. those are people that are going in with the idea you're not telling the truth. And those are hard to get past. But again, if you can go in and be very matter of fact and show you're truthful, even those judges will approve cases. But you have to just sort of do it a little bit, approach it a little bit different because, again, you're going to have to kind of get past the assumption the judge is making the presumption that you shouldn't be approved. But again, get that little bit of an edge, and that's part of what I do. I do what I do is I want you to have that edge so that you won't be one of these people that's kind of just struggling around and not really answering questions properly and frustrating the judge, and being on that, if it's a close case, being on the wrong side of that line. Okay. Jim says, reaching appointment reveals worsening condition, spinal stenosis. Yeah, I mean, I think that, that is showing a progression of your back condition. Spinal stenosis is when there is, whether it's just arthritis and bone spurs, but the space in the vertebra where the spinal cord goes through starts to get compressed. It starts to get smaller. And so the spinal cord is being compressed a little bit. And so you're going to get that nerve pain. You're going to get that what they call radiculopathy. If it's in your lumbar spine into your leg, sometimes numbness, tingling, things like that. And so, if your appointments show that's getting worse, maybe you're getting to the point where you maybe need to be talking about surgery. That is part of your story. That's part of your narrative. I'm a big believer, if you follow me, in coming up with a narrative to talk about, you were working, you started having to take more time off because it was starting to become more painful, and things just have kind of progressed, in a negative way to the present day. And you're telling a story about a person reluctant to have to go through the disability process. You worked as long and as hard as you could, but just got to the point you just couldn't do it anymore. My case, a couple of days ago, my client had told me, he said, I was working. He had a job. He was a case manager, and he was going on the road to deal with various people for the agency he worked for. And so he went from full-time to part-time because he said what was happening was I would, have to drive to somebody's house to do what I did, and I would be in bed the next day. So I've been doing it a long time. They gave me an opportunity. So I went from, doing it 5 days a week to doing it 3 days a week so I could take a day off. When I agreed I would, come in if they needed me an extra day or two. So, just telling that story, presenting yourself as a reluctant claimant who is going through this process only because you have no choice. And I think that's, that's what you want to do. So, having this appointment that shows this is getting worse, that's part of your story. You want to incorporate that into the story. Elliot, I think I saw something from you today in an email, if I'm not mistaken. But anyway, DDS just notified me for a psych evaluation, mental status exam. I've been in federal quality review since 225 Bensing, first third-party questionnaire, then employee health. Now this, how many more steps? I think that there's obviously something going on there that they want to convince themselves that you are, your condition is at a disabling level. There's no way to answer how many more steps you're going to be dealing with. I mean, they're going to send you for the psych evaluation. There's obviously something in the record that suggests there's anxiety, depression, which, again, my experience has been that the psych evaluations oftentimes will give helpful information that would make your case stronger. So again, tell the truth. Just be as transparent as you possibly can. For whatever reason, somebody is looking at your case and has got some concerns that need to be addressed, whether it's a judge or an adjudicator. It's when they come up with it, when they feel satisfied, that's when the case will be moved on. Jim is the person who has the stenosis. Do I need to update? I think it's never a mistake to update Social Security about your spinal stenosis. I mean, if you can get the medical record. I mean, what I do is if a client contacts us, and we have actually on all the emails that go out, there's a link to a form, any new doctor's appointment, any new diagnosis, any new medication, whatever. If something comes up that is relevant, what my staff will do is they will send a note electronically to the adjudicator saying there's something new you need to be aware of, get that record. It's not, you can tell them, but they want to really see the record. So I would say, especially in this climate where things get lost, where things take a long time, if there's something new that can benefit you, be a squeaky wheel, notify Social Security. No harm in doing that, in my opinion. No harm whatsoever in doing that. Yes, Deb is in northern Iowa. It's 64 degrees in northern Iowa. So obviously spring is here. Iowa is, I've never been there. It's actually one of these places I hear it's really pretty. I mean, I'd like to go at some point. So I don't know when I will ever do it, but it would be kind of interesting. A lot of the places in the Midwest, especially in the summertime, you get the open space. I think it would be really kind of cool to see. I think I mentioned I'm going to Michigan, to Traverse City, Michigan this summer for a wedding. And I told my wife, I said, we're not, and again, in Atlanta, we'll go to Hilton Head, South Carolina. We'll go to 30A, because it's drivable. And now with the grandbaby, we're not going to be driving 10 hours or whatever. But there are a lot of places in the country that would really be kind of neat to see. I'm a photographer, so I like to, see different things. And so, one of the things on my bucket list is to go out to Utah and New Mexico. Been to Arizona a number of times, but Iowa, North Dakota, South Dakota. These are just places that I think would be really kind of cool to see. So, and if I get to Iowa, I will let you know. You can tell me where to go. So I suspect there's probably not, a million things to do there, but again, just open space. Denise, my pleasure. And thank Deb as well for responding too. All right. Bala 2001 just started a recon appeal in New York. Any idea how long this may take? Should I get a lawyer? How long will it take to get a hearing scheduled? Does that get approved? As far as whether to get a lawyer, I mean, the pros would be that your lawyer would be get access to your file electronically, can kind of see what's going on. Can submit things for you electronically, so you don't have to rely on Social Security, associating paperwork with your file. On the other hand, if you've already filed the appeal, it's, the odds of getting approved are pretty low, about 15%. It's other than, you don't want to miss any deadlines. You can catch lightning in a bottle, get approved, and do it without an attorney. I don't think an attorney is going to make a huge difference. The big thing I think the attorney would do is make sure that there's copies of decisions are being sent to the attorney, so it's not going to fall through the cracks. And really, what I do, it's not even me; it's more Jen and Iris and Madeline, people on my staff. They'll log into the electronics folder and they'll look, and I do it sometimes. Is something going on? Are medical records being requested? Is the file being worked? And if we don't see the file being worked, we either will reach out to the adjudicator, by electronic messaging, or we'll tell our client, contact your U.S. senator, contact your representative, and tell them, you filed this recon back in, August of 2024. My attorney has looked. There's nothing in it. We'll give you a printout. There's nothing been done in 6 months. This is a struggle for me financially and emotionally. Will you help? Will you, initiate a congressional inquiry? And I will tell you, again, I've been looking at files the last couple of weeks, a lot of them. I'd say 8 out of 10 files I'm looking at now, my suggestion, my clients have requested a congressional inquiry. Those cases are getting scheduled for hearings faster. That's the only thing I'm aware of that will work. So I'm telling you, if once it's been 5 or 6 months sitting there, contact your congressperson. I say senator more so than representative, because senators, they're there for 6 years. They typically have a more stable staff. But say, give me some help. I mean, you're working for me. I vote for you, or you want my vote. You need to help me. And I'm not saying, weigh the scale, put your thumb on the scale. I'm just saying, ask Social Security to process my case so I can at least get a decision on it. Matt F. I'm turning 49, turning 50 in June. Combination of physical, mental health impairments, neuropathy in both legs, severe pain, swelling, anxiety, panic attacks, PTSD, fibro, and fatigue. Well, Matt, I will tell you, fibro is tough. Males with fibro, that's a real uphill battle. But the other things, the neuropathy is, an EMG, a nerve conduction study could document that. An MRI could show, some sort of nerve impingement, spinal stenosis, something like that. When you turn 50, the grid rules at sedentary could potentially apply. And that means that if you can prove you're limited to sedentary work, and sedentary is defined as sitting 6 hours out of 8 hours in a day, standing and walking up to 2 hours. A lot of people don't realize that. Sedentary for Social Security purposes requires you to stand and walk for 2 hours a day, lifting 5 pounds frequently, 10 pounds on occasion. And if you've got no transferable skills or no past work at all because you haven't worked in 5 years, then the grids could apply. So it definitely helps being over 50. It's more help if you're over 55, but I think that all these things you've got, if you can document them, the mental health issue could really eliminate any finding of transferable skills if you've got memory issues, focus issues, things like that. And if you have medical doctors will say that you are limited to sedentary work, you might very well have a grid argument as of your 50th birthday. Now, if you applied when you were 48 and your 50th birthday means you're going to lose out on 2 years of past due benefits, you got to think about what you want to do. But if you're getting ready to apply, or if you just recently applied, a lot of judges, a lot of adjudicators now are approving people as of that landmark birthday, the 50th or the 55th birthday. You've got to make a decision if that's something you want to do. Cindy says, thank you, Jonathan. You're welcome, Cindy. Sean, can you explain the process if SSDI would terminate one's benefits? Well, what they do is they send you a notice of, they're going to do what they call continuing disability review. They send you either a short form or a long form. The short form is basically, ask if you have any earnings. And they ask you, has a doctor said your condition is worse, the same, or better? Like 5 questions on it. These are, assuming you answer no to all of them, it's processed electronically, and they usually that's it. Some of them they pull by hand just to quality control, but for the most part, if the answers are no and everything, it's not going to. They're just going to calendar for the next one. A long form is like 5 or 6 pages of questions. A human being will read that. And so if they look at that and they see that there appears to be improvement, and they request updated medical records which show improvement, and they're really going after mostly people in their 30s and 40s, I will just tell you. But if they see there's medical improvement or an absence of going to the doctor, what they're also looking for are people who are not going to the doctor anymore, because Social Security equates not going to the doctor with not needing to go to the doctor. That's not correct, but that's what they assume. So, if they feel like there's been medical improvement or their earnings, which suggests you have regained capacity to work, they will then move to terminate. If you get a notice that they're going to move to terminate, you have 10 days to request that benefits continue while you appeal. If you don't request it, benefits will terminate. The positive is if you request benefits to continue, you keep getting your money, but your risk is you become overpaid. If you eventually lose, you owe that money back, although you can't bankrupt on it. The bigger problem is if you have benefits continue, you won't be able to get an attorney doing this in contingency because there's no contingency. You're getting your benefits. If you choose not to have benefits continue while you appeal, you would be able to get an attorney theoretically under a contingency fee contract, and you're not potentially putting yourself at risk of an overpayment if you should lose. So it's a very difficult choice to make, because if you rely on this money for food and shelter, and then it's going to take 2 years to get to a hearing, that's a long time. But that's the process. So you have the right to appeal it, and basically when you appeal a notice of termination, again you have to find the form. I would use Form 795 to request the benefits continue, or the default is that they don't continue. But you have to fill out the form, and then I think it's the 561 request for reconsideration. So essentially, motion to terminate is almost like an initial denial. You have to file a request for reconsideration. That's going to be 8, 10, 12 months. And then you have to request a hearing, which will be another 5 to 6 months. And by the time you get a decision, you're looking at a couple of years. So that's what's going on. You have to file a request for reconsideration, but they will only move to terminate if there's some indication that something has changed. Either earnings show that it has, or there's lack of medical treatment, or medical treatment shows some sort of improvement. Mark is one of my clients. How are you doing, Mark? Hope you're doing well. Vince is another one of my clients. Vince in Michigan. Hello, how are you doing? And Deb is asking Matt about whether he's the one with a neuropathy in both legs and fibromyalgia. Are you seeing a pain management doctor? Are you on gabapentin, which are Neurontin, which is a nerve pain medication, Lyrica, which is often used for fibromyalgia? These medications can have side effects, but they're also a sign to the judge that, doctors have prescribed these medications. You're signaling to the judge it's serious. They're not going to prescribe these kind of medications, gabapentin, Lyrica, unless there is something really going on. So that is a message to the judge based on what is prescribed to you. It doesn't mean you're going to win. It just means that is some addition of severity. But I still say male fibromyalgia cases, very, very hard to win. Very hard to win. Tommy Rowinski. He has been on Social Security disability for 4 years, moving back to Michigan from Florida in a few weeks. Spent the last 2 lining up seamless transition of doctors and records. Any further advice? Prepare myself to any hiccups. And it says traverse in the summer is awesome. Everybody keeps telling me that. I think, Tommy, you're doing exactly what you need to do. And you bring up a really, really good point, and that is that when you move from one place to the other, it's not always easy to get new doctors, because many doctors are, very limited as far as the type of insurance they take or Medicare, and it can be a real struggle. I've had clients that move 3 or 4 times during the course of a case, and there could be a 6-month gap in their treatment records because they can't find a doctor. And, while Social Security judges they understand it doesn't solve the problem of I need records. So what you're doing is really smart, is you've lined it up ahead of time. You've got your doctors in Florida talking to your doctors in Michigan, and you've got new doctors, so there won't be this large gap. And I think whether you're trying to avoid a continuing review, whether you're trying to get benefits, gaps in treatment are not good, because remember, Social Security sees absence of treatment as the absence of a need of treatment, even though there's no correlation. I mean, if you need, if you can't get to the doctor because you can't find a doctor, that doesn't mean you're not, affected. You're not ill. You don't have a medical issue. But, without evidence, Social Security, is a boat that floats on the sea of evidence. Got to have evidence. But I think what you're doing, Tommy, makes a lot of sense, and it's smart to do that. And anybody who's getting ready to move, especially if it's going to be more of a permanent kind of move, you want to try to establish your medical team where you're moving to. Look, I have people that I had a case the other day. My client was in Georgia because of the cost of living, moved to a small town in Alabama, and she stayed in Georgia for a year because she wanted to stay near her doctors, because it was so hard to find specialists in the small town in Alabama. And she had this hearing coming up. She knew that. She's like, I don't want to have this gap in treatment. And it was too difficult for her to drive back and forth. It's like 4 or 5 hours. She's got a lot of back pain and so forth. So she basically just lived with her daughter for over a year so she could continue going to the doctor. So, it's a really big deal to stay with the same doctors and to maintain treatment. But yeah, getting it lined up ahead of time is a good thing. Martini Shot says hello, and hello to you, Martini. Looks like is that, I'm not sure if that's Venice. It looks like a little picture in your icon here of a gondolier rowing under Venice. I was actually in Venice many, many years ago in Italy. And if you don't know, Venice is built on water. It's on a series of canals. They don't have streets the way we have streets here. You get around on these gondolas where you have these guys with the big sticks that, kind of push the boats along, or you walk. And what was interesting about Venice at the time when we went, it was, again, many years ago, probably 20 years ago, the food was awful, I got to tell you. But it was really, compared to the rest of Italy, it was really quiet, because there was not all the honking. The Italians are known for the honking of the horns and the motorbikes and so forth. It was just very, very quiet. I think Venice, though, is sinking. So, I know they've had to do some dredging and things like that, but it's a really interesting place to see how people have managed to live, without really using cars and living in a city where, transportation, at least for part of it, is by boat. So it was really an interesting place to go. At some point I'd like to get back, but, who knows? Right now, I don't know if Americans are all that popular in Europe. So I'm not planning on going back anytime soon. All right. Lily says, my U.S. Senator applied over a month ago as a medical review. Been there since October. Does the Senator inquiry actually assist moving the case along? It absolutely does. I will tell you without a doubt it does. Again, I had a bunch of hearings this week, and I think 4 out of 4 had the congressional inquiry in there with it. All it was a form letter from the senator saying, my constituent wants to know what's going on. And there was a response from the office manager at the DDS saying, the case has been assigned to somebody. We're working on it. We'll let you know. Just letting the fact that they know somebody's watching, it's just easier just to, to deal with it and, put that one at the front of the line than to ignore a senator, because they don't need, they've got enough trouble with, Congress not funding them. They don't need to make enemies out of any senators. So it absolutely does make a difference. They can't do more than what they can do. I mean, they can ask for something. They can make it aware that they're looking at it. They can't put their thumb on the scale to get you approved when you're not, if the evidence is not there. They can't force them to put you at the front of the line and deal with it tomorrow. But the fact that somebody in power, there are 100 senators in our country, and that one of 100 senators who's got a certain inherently political power is asking what's going on with my constituent, they're going to pay attention to it. So absolutely, that makes a difference. SA, you know who I am. I do. Can lumbar spine osteoporosis qualify for SSD along with other problems? Can I refuse osteoporosis treatments? Doctors say they're harsh and make you feel like you have a flu. All right, so the one question we've got is, if you are given an option for certain types of treatment, medical treatment, whatever it is, surgery, medications, infusions, whatever, and there are painful, unpleasant, or dangerous side effects, you can refuse to take those treatments, but you have to be able to explain that the reason why you chose to refuse the treatment was because of concern about, negative side effects, or, death, or things getting worse, or pain, whatever it may be. So I think you need to spell out why you're refusing it. It's got to be more than, I understand, it's makes you feel like you have the flu. I think I would go more than that. It can make me very sick. It can be dangerous to my health. I'm already in a weakened situation. I've looked up these medications. They are very, very powerful. They can affect other organs. They can affect my, thyroid gland, whatever it may be. But I think, feeling kind of having a flu for a couple of days, I don't think that's probably enough. I think you need to do more than that. So the answer is you can refuse treatment if you have legitimate and well-expressed concerns about side effects or potential danger. Osteoporosis obviously is a weakening of the structure of the bone. It is not inherently disabling, because until the bone fractures or there's a compression fracture, there is no problem. A person with severe osteoporosis, you could argue, a judge could say, or certainly if the record reflected that a person needs to be careful, this person needs to avoid working around unprotected heights or dangerous moving machinery or vibrating surfaces, let's say. But beyond that, until there's a problem, there's really not other limitations that you could not do. So I don't think that osteoporosis is an inherently disabling condition. Will it get rid of certain categories of jobs? Yes. All jobs? No. So I think that it is a factor. And again, what it would tell me is, at your hearing, assuming it's well documented, I would expect the judge would limit you to, again, jobs that do not require jumping off of, raised surfaces, vibrating equipment, working on unprotected heights, hazardous equipment where you put yourself at risk for a fracture because of the nature of the work. You're not going to be using a jackhammer, in other words, but you need more than that. But yes, it is a factor, and it will eliminate a 10%, 15% of the jobs out there. So it helps, but it's not enough on its own. Okay. Jim is currently in SSDI for 3 years, 59 years old. Has hurt my case. Your doctor wants to try pain medicine for spinal stenosis. No. I think that if the doctor wants to try something and you agree to it because you think it makes sense and you're satisfied that there will not be, really bad side effects or whatever, the question I'm sure you're asking is what happens if the pain management is so precise that it allows me to my function to restore such that I could go back to work. Well, I would tell you, first of all, if you can go back to work, go back to work. You'll make more money, you'll be happier. And certainly you have the 9-month trial work period to try it. So I would say if the pain management is successful, then give it a shot. The real issue I would tell you is you don't want to be in a situation where you're able to work enough that you're over SGA, the $1,620 a month figure, 2025 numbers, but you're not making enough to survive on. So you don't want to go back to work enough to, kill your disability case or to take you off disability, but not enough to survive. That's why they have the trial work period. So, I would say, listen to what the doctor says, give it due consideration, do your own research or due diligence about the medications. Do they scare you for whatever reason? And if you feel like you can give it a try, after a few months on them, again, the dosage is regulated. If you want to try to go back to work, use the trial work period. Be aware you've got 9 months in any 5-year period of time to try to work. And so, by month 7 or 8, you should know whether this is going to be successful or not. So that's the way the system is supposed to work. Our essay says the surgeon said L5 nerve blocks are the same as epidurals. Already had 3 epidurals since January 2024. I have to get another epidural. Did you know a nerve block is the same as it's not exactly the same. I mean, it's similar. Epidural is where they're injecting, kind of a numbing medication into the spinal, to the area of the spine to sort of numb the pain. A nerve block is where they're actually going after the nerve to deaden the nerve. It's more like a radio frequency ablation is sometimes what they do as well. So it's similar. It's not going to solve the problem. I mean, basically, it is going to mask the symptoms. The thought being that if the pain is masked enough where you could go to physical therapy, you could do strengthening exercises so that you might be able to work around the underlying pathology, then it might help you get better. It would also take some of that pain away so you'd be clear-headed. And there are some situations, and I've seen them, where people get epidurals or nerve blocks. They then go to intensive physical therapy and they get better, because they now are stronger elsewhere. They've been able to strengthen their core, let's say, or they're strengthening other muscles around the part that was deadened. But many times the epidurals, these sort of minimally invasive procedures, are really only going to buy you a little time where the pain goes away for a period of time, but it's not going to really solve the problem. Again, sometimes it'll give you a good amount of time, a year and a half, whatever. But my experience has been if you're going to go that route, you got to really work the physical therapy angle of it so that you can strengthen yourself. And again, I think that this is one of these situations where you've got to decide whether the risk is worth it. I mean, anytime somebody's injecting something in your back, whether it's to deaden a nerve or to give you an epidural, there is a risk. I mean, I'll tell you a story that happened to me years ago. This is many, many years ago. I was practicing law in a small office, and my wife and I were practicing together. And one of the people in the office was this pain management doctor who later on, it was pretty obvious this guy was a major quack. But at the time, we didn't know. Dr. So-and-so, and he walked around with a little white coat and stethoscope, and he's a doctor. And so I played basketball at the time. I played up until a couple of years ago. And, I threw my back out. I mean, I was just in spasm. I was just miserable. And So, I missed some work, and then I came in and I was hobbling around. And so this guy's like, well, let me give you an epidural. Like, okay, And so he goes in the refrigerator and pulls out an epidural, and I'm looking at it, and it's like, it's supposed to be clear. This is not clear. So I'm like, let me take, I look at this thing had expired like 2 years previously. And this quack was going to inject my back with probably, certainly stale, expired, epidural medicine. It was probably, the seal had broken. It was probably, adulterated. It probably wasn't. It may have paralyzed me. And I'm just like, I said, you know what? I appreciate that, but I'll go elsewhere. I mean, so like I said, I didn't, and I'm not stupid. I mean, I'm an attorney. I dealt with this stuff before, and like I said, this guy, if I hadn't looked, you know, this guy would have injected my back, and I might be sitting in a wheelchair right now. So my point is that there is a risk, even in doctors that are good doctors, that the needle goes in the wrong way, and you got a big problem. So there is inherent risk even in these minimally invasive procedures. So my point would be that if you choose not to undergo this because of concern about bad results, or you're concerned that it may not solve any problem, or that your condition is too far gone to really allow for any kind of physical therapy, then there's nothing wrong with saying no. And if look, it also could be that you mentioned the osteoporosis. Maybe some of these agents that are used in the nerve block or the epidurals might be contraindicated for osteoporosis. That may be something to look at as well. So, these are just things you need to be very aware of when making your decision. But at the end of the day, you're the patient. You got to make a decision. But Social Security, if you have a good reason, there is law, there's direction, they will not hold it against you. Reese is the one who had coming up a telehealth appointment as well as a x-rays with a medical doctor. Can you ask for a copy, fill out the form to send to my doctor? First of all, it's very smart to have your own set of records. You can ask, they may not give it to you. It'll be part of your Social Security file. You can get it either through your lawyer, or when your case comes up for hearing, you can get it. In some cases, it used to be the adjudicators would send it to you, or you could make an appointment to go get copies of your file. I think it's kind of hard to do that now. It's hard to get through to anybody, but you'll be able to get a copy of that at some point. But sooner rather than later, if you've got an attorney. Blue Z says, at what stage do they request you see their doctor? Going to be after the hearing, after all your medical has been filled up by your doctor? They still okay? Yeah, they can. Social Security can send you to a post-hearing consultative evaluation. It doesn't happen a lot, maybe 5% of the time. The record, there's something unclear in the record. There's a conflict in the record, and the judge will send the person out for a post-hearing consultative. Again, if it's physical medicine, many of those doctors are not going to help you, unfortunately. So, they can send you out for one, but I would not assume it's going to help you. If you've got your own doctor, that would be stronger, in my opinion. But yeah, they can do that. It doesn't happen very often, but they can do it. Jordy Bear, what are some tips to understanding SSA laws, adjudicating process, case law for someone becoming a non-attorney rep? Jordy, I think that there are a number of different programs. There's a training program. I believe that NADR, NADR, has a training program for the people to get to pass the test. And there's a term for it. It starts with an E, non-attorney rep. So I would certainly go to the NADR, NADR website, National Association of Disability Representatives. There's one called NOSCR, which is mostly lawyers, NADR, which is mostly non-lawyers. There's a little bit of overlap, but NADR, I believe, has a training program for non-attorney reps. Watching this live stream, looking at my videos would be helpful. The more you can follow, get a list of blogs. Look at Charles Hall's blog, look at my blog, there's a bunch of different blogs out there. There's a bunch of people on YouTube that do, like Walter Knott does a live stream. There's a bunch of people. Michael Weiner does a lot of videos out there. I know there's just a bunch of people that are doing them. Look at John Foster. He's a medical doctor who has a YouTube channel about consultative evaluations. Just educate yourself. I think it would be helpful if you could find a mentor, somebody, and again, maybe the NADER program would allow you to do this, where you could sit in on some hearings with everybody's permission, listen to what goes on. There are books out there that have all the forms. You can look for those. I mean, again, I think a lot of it is, it's just stuff you can pick up. But, I think you just have to educate yourself. These hearings are not open to the public, but, get all the forms. I mean, go to socialsecurity.gov and download all the forms and see how they're filled out. And again, find somebody who's done it and get some examples of how to fill these things out. But I think really the best thing you can do is to get somebody who will be willing to mentor you and answer your questions as you go along, maybe allow you to do a little bit of a case and then take on more of it. Don't worry about getting paid at first, just trying to gain the knowledge. And then, at some point you'll get to the point where you will feel comfortable enough where you could take on a case, maybe an easy case, or maybe a case that's not a very good case, but get you a chance to get in front of a judge. I would definitely look up, there's a number of resources out there where you can see approval rates of judges. And, you need to know that when you go in. That's a whole other issue is to, what do you tell your client if they have a low approval judge? But you need to be aware of that and get some experience and observation with, again, permission from everybody about, what happens at a hearing. Look, a lot of the hearings were recorded. So, like I download the audio of all my hearings because if I need it for appeal, I have that available also for training purposes with my staff. They can listen to a hearing, they can see what goes on. It makes them more effective at what they do. So again, if you find a mentor and the claimant, that person's client or claimant agrees to let you listen to the hearing, that would be a really good way. That would be some really good things you could do. So those would be just off the top of my mind, but just immerse yourself in this, get some formal training, find a mentor, and give it a shot. Give it a shot. Okay, Blue City Garage. Took your advice and contracted my congressman. 20 months in the initial, went to CE 2 months ago. Now they want an eye exam. I'm 60. Whether they're trying hard to prove me or not. You can't who knows? Who knows? I mean, the fact that there's something happening, that's good. The eye exam, if it shows a deficit, might be enough to eliminate categories of jobs. I mean, what would be helpful, I think you have an attorney, Blue City, is to, have somebody put it all together. Almost do like a pre-hearing brief that talks about all of the issues you're dealing with and why they are impacting you functionally. Again, the narrative, the story, you want to put it all together. You can do that. If you're not represented, you can do that. You can explain why all the things going on. I can't see. I've got back pain. I've got this. I've got that. And this is how it affects me. I think that would be very helpful. And you said, by the way, that the congressperson sent a nice letter back to him. Look, you're a voter. And not only are you a voter, but your family members are voters. You could influence 15 or 20 or 50 people. And I suspect that if you got a positive response from your congressperson, you could put that person's name in a live stream, and there are right now 125 people watching this. So not all in your state, obviously, but if a congressperson is able to write a letter and create a positive impression, for somebody who might influence 25 or 30 or 50 people, that's a pretty good return on investment. So yeah, they want to help you. They want to help you. It's an easy thing for them to do. And they want to. That's what they're to do. I mean, they're our elected representative. They're supposed to do our business, and part of it is to get help from federal agencies that are overworked. Douglas Martin says, "Had my hearing, the VE said no jobs, plus a lot of objective evidence you think will be approved. Waiting to hear back. How long do I have? It's 2 weeks. Well, first of all, it's going to be 4 to 8 weeks, probably, maybe longer. That just depends on the workload. If in fact the VE said no jobs for every question, that is a very, very favorable sign. Now, I will tell you, just in be truthful, that I've had people reach out to me that said, I went to a hearing and the judge, every question the judge asked, the VE said no jobs. one with a guy who's a really bright guy, very high level job. I listened to the hearing audio, and that VE was asked 3 or 4 questions. And in 3 of the questions, the VE came up with a bunch of jobs. So, if you can get a copy of the audio, Douglas, I would tell you, listen to it. You might be surprised about what happened that you don't remember. Maybe you're 100% right. Maybe there was, every question was no jobs. And if that's the case, you almost certainly won. Objective evidence makes it much stronger. But I would get the audio and listen to it, because you don't know. And this goes for me too. Look, I'm telling you, when you're in the middle of a hearing, I'm really focused on, asking questions and writing down the judge's questions and listening to the testimony, listening to my client testify. And I miss stuff. And sometimes I go back and listen to the hearing. I'm like, wow, I don't remember that, but it's there. So I think it's a really good exercise, really, for all of you, anybody on this live stream. If you have a hearing, ask your representative, your lawyer, non-attorney rep, to get you a copy of the audio. They've just changed it now, where I think it's going to be an MP3 format, much easier to get. It was on OGG format, which you can still listen to, but a lot easier now. Do 2 things. Number one is get a copy of the audio. Number 2, ask your lawyer to send you the PDF file. We all now use services where they'll take your entire record, put it into one giant PDF. And it may be, 1,000 pages, 1,500 pages, one big PDF, but PDFs are searchable, but you have a copy of your medical record in one file that is portable. You can take it with you. You can use it down the road, for reference, anything you want. And then the audio, you've got an audio, you can listen to it. You, again, will be amazed at when you study your record and you listen to the audio, there are things in there, I guarantee you, that you didn't know about your own medical history or that what happened at the hearing. It's a very, very useful thing to do, and I would recommend it to everybody. Get the audio and listen to and look at the medical record and keep your medical record. Somebody before mentioned that it was a woman who said, I want to have my own record. I want to get a copy of that x-ray that the doctor is going to be doing. That's a smart thing. Have your own medical file. And if it's electronic, where it's not in paper, even better. You can save it, on a thumb drive. You can put it in a safe deposit box, leave it in your mom's house, whatever. Have that record. It's really a good idea to do it. SA is the person who was talking about osteoporosis, and Deb is saying, does a doctor want to do a vertebroplasty or kyphoplasty or medications? And what those are where they inject almost like a cement into your bones to shore them up. And what SA was saying was that it was very painful. And again, you're putting a foreign substance in your body, inherently dangerous. But, that's a very good question. What is the nature of the treatment? But I still say whatever it is, if they're putting cement or bone, from someplace else in your body into another part of your body, there is danger there. If it's medications, there could be side effects. So, but I think you want to be able to explain that you understand what the doctor wanted to do and you made a decision not to do it if you decide not to do it. And again, everybody's goals here should be to get better and to get function restored. So, don't dismiss something just because it could be a little uncomfortable. If it could help you, go for it. Look, you can always go for a closed period of disability if you're not going to be ongoing. But again, you're much better off working, in my opinion. Okay, so SA says for the osteoporosis, referring back to the doctor for medications that make you sick. Okay. All right, Douglas is 51. He's the person who said he got no, the VE said no to all answers. Again, being 51, having a VE say no jobs to the judge, a lot of objective evidence. These are all very, very, positive things. And so, it's very possible that Douglas is correct that he should be approved. But, again, you want to just, until you get the written formal, the formal statement that says, or the formal letter from Social Security that says fully favorable, that's when you believe it. And again, this is an ongoing conversation about the osteoporosis. SA is concerned that the epidurals are causing lumbar osteoporosis. Maybe, and again, what I would tell you to do is go to WebMD, go to the, just any of the, National Institutes of Health, go to the, the Mayo Clinic website, any of these places, and do your research to see, is the active ingredient in epidurals, is it known to cause osteoporosis? So you're better informed and you can make a better decision about your health. Okay. Yep. Okay. Turd Ferguson. Okay. I got a feeling your name is not really Turd Ferguson. That sounds like a Saturday Night Live sketch there. I have watched many of your YouTube videos in the past 9 years after being denied a hearing, finally being approved this week by a 20% approval judge. Thank you. Well, good for you. I mean, a 20% approval judge getting approved by that person, that is quite an accomplishment. So congratulations, Mr. Ferguson. And I think that is really cool. That is really cool. And I'm glad. And you know what? If you are so inclined, I'll put this up here. Leave me a nice review. I mean, if you learned from me was helpful, then leave me a nice review. That's how you do it, and I would appreciate that. Cheryl Hall is 60 years old. An SSD. I was married to my ex for 10 years. Don't have to wait till 60 to file for spousal benefits. I know that if you become disabled, well, if your ex-spouse is still alive, I don't know about retirement benefits. I'm just not the right person to ask. That might be a question to ask of an elder law attorney. That may be Greg. I keep drawing blank on Greg's last name. I don't know why. Let me just find it here. Greg Brinkley. Greg Brinkley. I'm sorry, Greg, if you're watching this. I apologize. Greg Brinkley might know. Greg at gregbrinkley.org. I just don't deal with retirement Social Security, so I don't know. Deb says the epidurals are the culprit for causing osteoporosis. So yeah, that would be a reason to not take one. Jen is here. Jen is Jen had a busy day today, so I'm glad to see you here, Jen. Hope things are going well. Tommy says. Tommy is the person, I think, on disability who is moving to Michigan from Florida, and he wants to know, did you need to make SSDI aware of a new diagnosis someone recently received, emphysema, completely different from the initial psych reasons? I don't think it's a problem to do that. I mean, I generally have always felt like until Social Security contacts you, no reason to really contact them. But yeah, I think if you got another diagnosis of something serious, it wouldn't be a mistake to let them know. On the other hand, sometimes being under the radar is not a bad thing, and you can certainly bring it up if they review you. But if your underlying case is based on mental health, maybe adding a physical component to it is probably not a bad idea. I guess if I had to say on balance, I would notify them maybe after you move that I've been diagnosed with an additional medical problem, emphysema, and that this is in addition to the other things, and I'll be happy to provide you medical information if you wish. But I don't think if you didn't do that, it would be a problem. But probably, if I had to choose, I'd probably fall on the side of yes, do that. Okay. I know SA and Deb are going back and forth, so we can kind of monitor that, but I need to jump in on it. So let's see. Martini Shot says, all right, does taking a Zoom class aimed at training for a light sedentary entry-level part-time job come against while waiting for my appeal to be determined? No, I don't think you'd take one Zoom class. That's going to be a problem. If you took, classes that were 3 or 4 hours a day for 5 or 6 months, that starts to look like SGA. But I think if you take one class to train for something you might do part-time, I think that works in your favor, because you would be basically saying to Social Security, and you could eventually tell a judge that, I'm looking to try to find something I can do. I took this Zoom class about whatever the topic was. And yeah, I'm trying to find work. So I think it shows you as being credible and that you're hoping to not have to stay on disability, be on disability. So yeah, I think that would be not a bad thing to do. It will not hurt your case. All right, Elliot has cerebral ataxia, almost 62 years of age. And I think you were saying that you're waiting for that they're asking you for all these different things, for to confirm your disability. But yeah, these are all very, very serious things, and I think that they should hopefully should approve. Okay, all right. So Deb is answering Cheryl about the spousal, and she's saying that you both need to be 62. So I don't honestly, I don't know. So I'll take that. I mean, Deb is very knowledgeable, but again, you got to do your own. Don't take anything I say or anybody else says as this is the law. Do your own research on it. So I don't want to get Deb in trouble or me in trouble for that matter. So just be aware that anything you see, what I'm doing here with this live stream is not legal advice. I can tell you my experiences, things, and certainly what Deb is giving you is not legal advice either. Do your own due diligence. Okay, JR has chronic gout, had it for 10 years, now progressing to TOFI, many fluid removal, showing crystallization along with knee deformity. Gout, as you probably all know, extremely painful uric acid crystals in various joints. A lot of times the big toe, could be the knee. Obviously fluid buildup. I think I would log, all of the times you've had the fluid removed. Keep a log of it. Keep a log of how often you take the medications, when they increase the dosage. Again, you want to tell your story. Of a person who's cooperating with the doctor, done everything the doctor has said to reduce the symptoms of gout, and nothing has worked. And you can show by, a log of the medicines you're taking. If the doctor said lose weight or go on a special diet, log that. All these things I think would be helpful to tell the story of that your body's just producing uric acid crystals and there's nothing you can do about it. I think every judge knows that gout is one of the most painful things you can have happen, and it's so distracting that you can't really work with it. But I think you need to document this frequency and severity of the flares, and I think logging it would be helpful, and of course doctor's visits would be helpful as well. Okay, Deb says she lives 38 miles east of where Buddy Holly was killed, so 86 miles south and west of Rochester, Minnesota. Okay, very interesting. And Rochester, that's another place I'd like to go is Minnesota. Never been to Minneapolis, but again, there's some really neat places, and one of these days I'll get out there. Cindy says, good information. Yes, very good. What is the OS Westry Disability Index? I have no idea. Let's see if I can look that up real quick. Maybe I know it something else. SWESTRY Disability Index. Okay, there's such a thing here. It's a self-reported questionnaire used to assess the impact of low back pain on daily activities. I just learned something, everybody. So this is a self-reported questionnaire. I've seen these in medical records. It is used by doctors to ask you to describe your back pain. I use this type of thing, and I didn't know it was called this. But when I'm doing my hearing prep, what I'm going to look at is how my client described his or her back pain. Does not mean that that this is a medical diagnosis, but it gives me some insight as to what my client is thinking. So when I ask questions, I can ask intelligent questions about this type of thing. Social Security does an adult function report used for the same purpose. So this is basically a way for a doctor to understand how severe you perceive the problem to be. And obviously, if the doctor then does objective testing, like an MRI or a CT, and the result of that objective testing is in proportion with the level of impairment you claim on this disability index, then that will give the doctor some guidance as to what to prescribe and to how to, talk about your medical issues in a disability context. If your self-reported score is out of context, if it's not consistent with the underlying medical evidence. That's telling the doctor that you have a very low pain threshold, or that you're maybe exaggerating, or that you're invested in being disabled. You're less likely to get cooperation from the doctor. So it's just a way for the doctor to get a sense of where you see yourself in terms of being disabled. And realize that many doctors are very concerned about people who decide they're disabled, because there's this mind-body connection thing going on. If you think you're disabled, you keep telling yourself that you're disabled, you will be less functional. If you perceive yourself to be not disabled, that you're fighting it, this is a temporary condition, you're going to have better results. And that is something that doctors are very aware of. And so they're going to want to know. This is a way for them to find out. That's really all that this is. Grid rules, Cindy says, explain well, very good. And I've got a website, a whole website about it called gridrules.net. So go there. You can learn more about it. I've got a bunch of videos about the grid rules. So, they're really, let me tell you something. I use the grid rules. Anybody over 50, I'm going to look at them. I make, in my pre-hearing briefs, anybody over 50, if it's physical, I'm going to probably make it, if I can make it, a grid rule argument. And a lot of here, it's interesting, a lot of my favorable decisions, the judge will say, I'm finding that his functional capacity is so reduced that he would not be reliable. However, even if the person had some functional capacity, the grid rules would still apply. So they typically use the grid rules as a secondary reason to approve after making a functional capacity evaluation, which is kind of interesting to me. But and occasionally you'll see it with this, they just look at the grid rules, but it just gives the judge backup. It's a second reason to approve somebody. DG says, is it true that Social Security regs stipulate doctors of chiropractic cannot be used as a medical provider to give credence to spine, cervical, and lumbar issues? That is correct. Chiropractic is considered alternative medicine. Same with acupuncturists, naturopaths, non-medical doctors. Nurse practitioners are considered acceptable medical sources. But whether this is the AMA lobby, I don't know. But yeah, chiropractic, what the value would be is if you go to a chiropractor, it does show that you're seeking treatment, but the chiropractor's interpretation of an x-ray or his or her diagnosis or assessment of your underlying condition will not be given any weight, but it will show that you went to get treatment. So it's, I hate to say it's like a massage therapist, but it's more than that, obviously. But it just does go to show you've gotten treatment. You're not just doing nothing, but the chiropractor's assessment won't carry any weight with Social Security. So if you're going to a chiropractor, go someplace else as well, is what I would tell you. Matt, if this is the person, let me go back to Matt's prior question here. Okay. Matt is 49, about to turn 50, is a combination of physical and mental impairments, neuropathy in both legs, severe pain, swelling, anxiety, panic attacks, PTSD, fibro, and fatigue. And then he is saying, in addition to that, I had to go down to part-time work, 15 hours a week, work at a call center job, sitting most of the day. Doctors elevate 3 or 4 times a day. I'm off task 20-25% of the time. I have an EMG. Big picture is looks like Matt is working part-time. The question is, are you over SGA, the $1,620 a month? If you're off task 20% of the time, 20% of the time, 25% of the time, that is excessive. But if you're able to keep your job and still work, you are not disabled. Now, call centers maybe have their own unique culture, where your income is based on what you earn, and so maybe they have a desk where they can let you call, and if you happen to work less hours one day, it doesn't matter to them. They have nobody else to fill the slot. If you're not elevating 3 to 4 times a day, again, the doctor wants you to, but are you doing it? Are you getting write-ups? But the big question is, are you earning more than $1,620 a month? So if you stopped working, okay, and you show that you were terminated because you were being off task and that you had to keep your legs elevated, that can certainly help your case. And if you're 50 years old, as of the time you're claiming your onset, that also helps you there. But as long as you're working and earning more than $1,620 a month, you are by definition not disabled. Okay, so Deb is talking about the epidurals, and she's saying anytime you use steroids, especially when injected at higher doses, the risk is greater for bone loss and damage. And, I think what Deb is getting at is that many people get an epidural and they don't really understand that this is a steroid that can have significant effects. And if you already have osteoporosis, that is not a good thing. And, are you is the doctor saying, well, don't worry about it? Or, are you really being given appropriate information? I think what she's saying is that I think where Deb would fall, I don't want to speak for you, Deb, but I think what you're saying is that it appears that, many doctors are not as diligent as they ought to be talking about the potential side effects of these steroids. Let me go back and put on the original case evaluation. Again, like I said, in this current climate, if you've not applied and you're thinking about doing so, don't wait. Whether you use an attorney or not, I think that it's just the delays are going to get longer. So I'd say go for it. Does SSA count my retirement against my SSDI appeal? If you're talking about private retirement, not Social Security retirement, no. I mean, that's non-earned income. It's just like VA disability. A retirement plan from your company is not going to offset as Social Security disability. Whether your Social Security disability offsets, but I don't think it would. It's based on your service for the most part. But no, it is not going to count against you. And Social Security is based on your earnings record and whether you meet the definition of disability. Peter was denied in 22. Lawyer didn't want to pursue it in federal court. Again, federal court work is expensive. It's time consuming, and only certain cases are going to be appropriate for federal court work. I will tell you, like if I have a case, I'll go to the appeals council. If it's denied, we'll go to federal court. I'll bring somebody in. I'll bring in Carl Osterhout. I'll bring in Brian Konoski. That's all they do is federal court work. Adriana De La Torre was another. She was here a few weeks ago. And so I bring somebody in who does federal court work. But they don't take every case because you got to have something that is clearly reversible. And so, if a federal court attorney takes a case that I prefer, there's usually a pretty good reason for it. So, maybe your attorney didn't feel like there was enough there. But at this point, 2020, that's 3 years ago, it's nothing you can really do about it. Okay. Ronnie's stage. I have congestive heart failure, ejection fraction 28%. Wear a life vest. Should I look for disability? Yeah, absolutely. I mean, ejection fraction at 28% is just above listing level. Very serious. Again, I don't know how old you are, Ronnie, but if you're over 50, I think that's a really, really strong case. The life vest 24/7 says that your doctors feel like you're at imminent risk of a cardiac event. Congestive heart failure being very, very serious condition. Even if you're younger, how many days are you so physically exhausted that you would need to be resting at home? I would definitely look into it. I mean, I think it's, again, given the long delays, don't wait on it. But if you can't work and you're not working, then absolutely look into it. If you're still working and earning more than $1,620, work as long as you can. But, just the two things you told me here, low ejection fraction and normal ejection fraction is like 45, 50%, I think, or maybe even a little higher. 28% ejection fraction is really, really low. And a life vest means there's something going on. So yeah, look into it. Absolutely. He can work a couple of days a week. Yeah. I mean, I think you're answering your own question. That's and Deb says, are you able to work at all? Yeah. A couple of days a week. That's not going to be SGA. So I would definitely think it's worth looking into. I would definitely look at that case. I think it's potentially a very strong case. Oscar Vega. I have osteoarthritis. Doctor sent for physical therapy. Have FISTER. I'm not sure what that is. In the past, I had 2 shots on my shoulder. Nothing's working. Should I go back and do it again? you got to make a decision about your medical treatment, talking to your doctor. I think that, you know, physical therapy injections are what they call conservative treatment that are done before they start looking at doing a, shoulder surgery or shoulder replacement. So I would certainly exhaust all conservative treatment with your doctor's help before looking at something like a shoulder replacement. So my advice to you would be talk to your doctor, and get some guidance from the doctor about what to do. And I think that exhaust conservative treatment. Okay. Mrs. K seems shocked about something there. Just stop by to say hello, everyone. Hello, Mrs. K. Ronnie just started seeing cardiologist a few weeks ago, adjusting medications, making a plan. Yeah, you may want to see how that goes, but realize that disability process can take a long time. If you start it and then you later on, get this under control where you can go to work more, you can always discontinue your disability case. But if it's going to take a couple of years, start sooner rather than later is my thought. But, again, I think, waiting a couple of weeks is not going to make a difference. But if you can get a sense from your doctor whether there's likely expected significant recovery, that would be something I would ask a question about. Bala 2001, stop getting epidurals. Again, this is kind of going back to SA's question. Super painful and absolutely no result. Pain management system doing it gets it right. I decline, it's bad for my case. How useless having a chiro. Again, chiropractor is not going to be able to make a sort of diagnosis or assessment that means anything to Social Security. If your pain management doctor, you're in an impasse with the pain management doctor and you feel like the epidurals are not helping and potentially risky, maybe you look at another pain management doctor. Again, I think that you should be in control of your own body. Your doctor recommending something, obviously, the doctor probably doesn't want to prescribe painful narcotic pain medication, but if the epidural is not helping and potentially is putting you at risk for osteoporosis or something else, then you got to make some decisions about that. Maybe go back to the orthopedist or the other other specialist, neurosurgeon, and maybe have a surgical consult, because maybe you're in an impasse with pain management. The doctor's like, well, this is what I do, and if you don't want to do it, then I can't help you anymore. Get released. But again, you don't want to have that as you're refusing it. I think you want to make sure you explain why you're refusing it. But this is sort of that part of that narrative where you ended up, now you're really talking to somebody about surgery, or you find a different pain management doctor that will give you medications that will let you at least function somewhat. Okay. Ronaldo Productions, 61 with many issues, diabetes since 2008, anxiety, essential tremor, med side effects. Does it make sense to still apply for disability, drag myself somehow at 62 and retire early? Well, realize if you are not working, when you stop working can be your onset date. So you can certainly file for disability at 62. You can go ahead and take your early retirement. And then if you win disability, two things happen. One is you get a past due payment for time that was spent up until the time you turned, or up until the decision's made. Secondly, is that your early retirement Social Security becomes full retirement. You're not stuck at the lower figure. And the third thing is that your Medicare will kick in 2 years after the date of first payment for Social Security. So you get Medicare faster. So there's any number of reasons. Again, Medicare, you're going to get faster. You'll get a higher retirement when you do hit full retirement age, because disability and full retirement are about the same. And you may get some past due benefits. So it's definitely worthwhile to consider. If you're working and making more money, then okay. But if you're not working and there's no reason not to file for disability, go ahead and do it. What is a rating of disability? Okay, so this is asking about that Westry Disability Index. What is a rating of 50? I don't know. I think maybe Deb knows. I don't know. Jackie Johnson. I've been on SSDI since 2012 for severe leaky gut. Yeah, those kind of cases are winners. Anxiety, depression, migraines. Last letter, no CDR at this time. Well, you're probably not. I mean, you're 60 with leaky gut and hadn't gotten better in over 10 years, 13 years. You're not going to have any more CDRs, I think. All right, so Deb is telling to Ronnie Stage, talk about your next appointment. Yeah, I think this is about the cardiac and what the doctor is going to say. I think absolutely, I would agree with what Deb is saying. And that sounds like a good, I mean, somebody called me with those facts, I would take a really long look at it. It sounds like a pretty good case. Annabelle says 58% on the Oswestry index is significant disability affects the quality of life. Realize it is filled out by the claimant, by the patient, not by the doctor. So this is your self-report. And, the doctor is going to be more focused on objective evidence like the MRI or CT. But this will be part of the puzzle, Nicole, is there ever an approval without going to trial? Yes, absolutely. I've had it happen many times. An on-the-record decision. I had a case a few weeks ago where I got a call the day before the hearing. The judge is going to approve the case. I get cases approved at the administrative level. I get cases approved in my pre-hearing brief. So it does happen. You got to somebody read it who can make a decision. But I would probably tell you that 15% of the cases, 15 to 20% of the cases I take get approved without the need for a hearing. I take pretty good cases, but decent percentage I do. Okay, the rating of the disability indexes from a chiropractor, which don't understand whether or not considered, have a report. You can submit it. Again, this is your self-report. So this is almost like you telling Social Security what hurts me. The chiropractor's interpretation will not hold any weight, but it would help me as an attorney know more about what was in your mind at this point in time. But it's probably not going to move the meter as far as an approval. It's self-reporting. So you're telling them what you perceive, not what the evidence says, but you need to have more than the chiropractor, unfortunately. Okay. Yeah, I think, Deb, I think if I'm not mistaken, you're on disability yourself. So you are using this form to help people, which I appreciate and know they do as well. Annabelle, yeah, that's true. They don't. Yeah, it's just, I think the AMA has a big, American Medical Association has a very powerful lobby. And, Western medicine looks at procedures and medications. And, whereas Eastern medicine is a lot more mind-body type of thing. And, look, acupuncturists can do some amazing things. Chiropractors can do some amazing things. Physical therapists, which is considered an acceptable medical source, can make a real difference. Should Social Security be more open to, non-invasive procedures? Sure. But, realize they want to find a way to approve fewer people. And if they have to take chiropractors or non-Western medical providers at face value, that'll be more approvals, which they don't want. So that ain't going to happen. Let's see. I got all applications sent to SSD in March, but I state that I stopped work in January. Monthly income start in January or March. Neither, because if you're SSDI, the first 5 full months are considered a waiting period. So if you allege that you became disabled sometime in January after the January 1st, January 3rd, the 10th, whatever, the first 5 full months, they don't count January. That's a partial month. You got February, March, April, May, June. Your first payment would be July of 2025. SSI would be immediate, but if it's SSDI, you won't see any money until July. Okay. Let's see. Yeah. Deb says don't even submit it. Again, I think it's part of the puzzle. It's evidence. I don't think there's a problem, but that's a judgment call on your part. Certainly, a chiropractor. Look, I have plenty of cases where the chiropractor's records are in the file. I don't spend a lot of time looking at it. I mean, again, what I would note is the dates of treatment and how many treatments the person got. So I can say at least to the judge, well, the person, they went to a chiropractor, They had 15 visits in this 4-month period of time. They were seeking some sort of relief, and that's all I can really say about it. All right, Madeline from my office is here. Good evening, everybody. Hello, Madeline. Michael says, your vids helped me out a few years ago to get full benefits. Thanks. Type 1 diabetic on the first try. Great. That is good to hear. I just actually had a really interesting hearing the other day for a lady who was type 1 diabetic. It was having a hell of a time getting it under control, and is really, has multiple episodes of diabetic ketoacidosis, was having, hospitalizations, had the numbness in the hands. Type 1 is really serious, especially the longer you have it, the more it eats away at you. So, Michael, I'm not surprised you got approved, and I'm glad you did. And again, if you found my my videos helpful, whatever, go and give me a nice review. Go to jonathanginsberg.com and click the review me, or go here. I'm going to put this banner up there. If you're enjoying this, go to bit.ly, Jonathan-review-5. Leave me a nice review. Most appreciated. Most appreciated. Okay. Let's go back to our comments here. And Boss Biga 24. Do I need to be hospitalized for a mental health case? Go to my program. You don't need to be. I mean, again, you need to show it's serious enough where it's not just mild to moderate. If that's the main reason you're claiming disability, it has got to be serious enough where it's going to interfere with your ability to function in a work environment. And so mild to moderate generally is not going to be there. Hospitalization is an indicia of severity, suicide attempts, indicia of severity, multiple failed medication trials, indicia of severity. That's been my experience. What strategy do you recommend to keep and maximize? I mean, main thing is got to go to the doctor. Having objective testing makes a big difference. Not having gaps in your treatment record, having something that is clearly diagnosed makes a big difference, and then really focusing on your functional limitations. That's the key. Okay. Annabelle says that you listened to me for years. Thank you very much. I'm glad to hear that. Yeah, I enjoy this, and it gives me joy when I see somebody saying that they got approved because of my videos. Again, I got plenty of business. I'm very happy about that. But if this helps, that's good karma I'm putting out in the world, and it comes back. So that's really cool. JR, you are very welcome. Very welcome. Tara Upshaw, how are you doing, Tara? Good to see you. And Scary Sherry. Once you get out of recon, you file a request for hearing, 5, 6, 7 months. Basically, you'll get a hearing. Let's see. Annabelle says, I would never just my own personal reasons to have to deal with Social Security just without an attorney. Yeah, I understand that. I mean, I think Social Security can be faceless. It can be unforgiving, and they expect that you know what they want. And, there is a pretty good argument that says that, having an attorney, certainly statistically, people with attorneys in disability cases have a higher percentage of approvals. Okay. Okay, so it's worth 25%. Again, that's what we get paid. No fee unless you win. But I appreciate that, Annabelle. Okay, we got about 10 more minutes here. Roy's Place. Roy, okay. Long-time listener, thank you, work. I might expect a response to a letter from SSA in response to asking me if I work. Some proof check substrate. They may or may not respond to you. I mean, it just depends on how busy they are. As long as you responded to them, that's the key thing. But they may or may not acknowledge it. They should, but they may not because they're just too busy. All right, so now we're in a discussion about chiropractors. Chiropractors just hurt Ray. Annabelle says go to orthopedist. Chiropractic is it's a non-invasive type of treatment, where they're adjusting your body to hopefully help it heal itself. I will tell you my own experience. I've gone to chiropractors off and on over the years. There's a friend of mine who's a chiropractor not too far away from where I live and work, and I'll go in if I'm really tight. I'll go in to see him. He's changed a lot. The way it used to be, they would do all the the manipulation, you really hear it. A lot more subtle now, not nearly as much cracking and twisting. It's more massage based and just kind of softer, as maybe the way I put it. And I think that, there have been some cases where chiropractors have been sued for hurting people, and they can. You can tear a vein, you can herniate a disc. And so I think that chiropractic, the continuing education they have, I have to ask my buddy about it. I'm getting the sense that they are less physical in the way they do manipulations. And so, again, it's more like a more gentle type of massage. I'll have to see. But again, it's just not given much weight in Social Security. Okay. Annabelle says, primary care doctor prescribes medicines for other issues. If your doctor up to Venice has the eye and continue treatments constantly. Yeah, you know what? You're right. You're absolutely correct. I think that you need to be ongoing medical treatment. You've got to get medications. They're expecting to see a full Western medicine history. And it's got to show that none of it's working or very little of it's working and that you remain disabled. I think that's a pretty fair assessment. All right, SA are very, very welcome. Doctor of osteopathy. Okay, so an osteopath is a medical doctor. They're not an MD, but they have a lot of the same training and privileges. So there's not that's given weight. That's considered an acceptable medical source. So that is fine. Okay, I've got time for a few more here. Andy, I'm not going to. And Pantilla 83B. Good evening. I'm an end-stage kidney disease on dialysis and 4 stents. Been hospitalized 4 times. Absolutely, Andy. You have a winning case. You're working. When you stop working, you would get approved right away. You're on dialysis, 4 stents. You will be approved as a listing level case. If you can work and make money and you can, interact with people, do that. But the minute you stop working, you apply, you will get approved forthwith. I will tell you, because that you are disabled. You are clearly disabled. Darlene, one of the our firm Ginsberg offices, and somebody decided that they're the golden girls. I guess how they pronounce it. But my staff, that's what that's what they talk about. They're not doing work. They're talking, making comments about how they name themselves. I'm just kidding. They all work really hard. Darlene is one of them. I've known Darlene for many, many years, and she and Madeline do a lot of the call screening, and are both very, very good at it, which I would say. And then, of course, Jen is doing a lot of the back end work, and everybody kind of pitches in. Or Darlene, good to see you. Glad you could tune in. Annabelle, do I know the final thing your attorney said before we signed our checks? Don't go back to work. Yeah, I don't know if I agree with that. I think that, if you can work, you should try to work. It is not, disability is, it's boring. I mean, you're at home, you're getting a check, for being disabled. But you can't really do very much. It's very easy to get very, very decompensated, where you're just not getting any exercise, not a lot of stimulation. I think work for human beings defines us in many ways. And I think if you're working, there's a social component to it. You feel like you're earning money, it's worthwhile. Yeah, I just think that if you can try to work, just have to be careful not to work too much to where you're working too much to get disability, but not enough to support yourself. But I say I disagree. I think you should try to the extent that you can. Okay, I think you meant Darlene, no Sky, not Dawn. Anyway, and Annabelle, again, Annabelle's on it. She's absolutely right. The trial work period is very tricky because there's no real-time reporting, so you got to keep track of it yourself. Absolutely. Okay, no Sky got it right. There you go. If you're able to get to a chiropractor, that's ridiculous. Come on. Going to the chiropractor is, it's a legitimate thing to do. It's just not going to help you in Social Security very much. So I think Deb agrees with me that Andy Gurr, dialysis would make you disabled. And right, Darlene is here. Okay, so now we got everybody telling each other hello. Okay. All right, Jackie Johnson, my husband. See, all my staff is here, and I appreciate it. This is after hours. I got Darlene, I got Madeline, I got Jen. So that's pretty cool. That's pretty cool. I'm glad to see them all there. I think they want to. I always talk about this. They probably want to see me in action here. So, and how are you? All right, my hubby has an ALJ hearing this month. Had pericarditis vocational assessment done. Will the ALJ use it? Yeah, they'll use it. In fact, I had a hearing just the other day where there was a very long vocational analysis that my client's VA lawyer had done. And we submitted it, and I referred to it extensively in my brief. So absolutely, it's very helpful evidence. Yeah. And Scary Sherry. I love the name. Been in recon since October. Is something that, well, once the recon decision's made, you'll get a hearing date usually in 3 or 4 months. But you got to get the recon decision made. Yeah, Darlene's heard about chiropractors. I got to ask my buddy Art. He's a chiropractor. I just got to ask him because that's an interesting question. Okay. We got a lot of hellos. Annabelle is 63 and trying to get in trouble with trial work. Yeah, I mean, trial work can get you in trouble if you're not careful. I agree. DDS examiner says, John, call me with a few questions. Onset day is transferring to another case department for decision. What department would that be? Probably for a medical assessment, be my guess. And as far as how long it can take, I can't even begin to tell you. I don't know. I do not know. Okay, let's see if we have any more. And, this maybe is a good time to stop. We're right at a couple hours. And, we got one more here. We got Ron Small. I had 2 hearings a month apart where they have another one. I think that sometimes judges need to hear more, and they'll schedule another hearing. It's not that typical, but it does happen a little bit. Okay. Jonathan L., I see you're up, but I mean, again, it's going to just depend on the effect of all this on your functioning. GR Gomez is, well, that's good. I'm very, very glad. Jonathan L., we'll make this the final thing. Jonathan L. has a number of different diagnoses, which I've listed here. Focus on those things that interfere with your capacity for work. Esophagitis makes it hard to swallow, is uncomfortable. Maybe you throw up. Maybe you have days you can't get into work. All the things that are functional. You look at each condition and write down the things that are most impactful to your functioning and that the medical doctors, your medical record supports. That's what I would really focus on. It's all about functional issues. You don't win or lose a disability case based on diagnosis. You don't win based on, what a doctor's told you. It's basically, if the doctor goes on a record that you have a medical condition that's going to cause this functional limitation, that's what you want to really focus on. And anything with objective testing will be that much even better. So that's what I would tell you. Functional issues, that's the thing I want to leave you with. That's what the focus is for disability case. Okay, we are now at 2 hours. I'm going to end this. I hope everybody who's got a hearing coming up wins. I hope that you're successful. If you're thinking about filing for disability, you want me to look at it, please feel free. Here's the link there. The Contact Jonathan link, Contact Jonathan 3, reach out to me, and you'll talk to Darlene, you'll talk to Madeline, you'll talk to me. We'll give you our sense of what's going on and whether we think you have a case, and happy to do that. And again, if you're not already subscribed to my YouTube channel, please do it. We've got, again, a Facebook page. I'm going to be putting more stuff on Instagram. Look for me at Ginsberg Law Offices on Instagram, but definitely on the YouTube channel, hit that subscribe button and the bell. That way, when I put a new video out, you'll get a notification. I recorded a bunch of videos today, although I should have probably waited till Friday. I'm getting my haircut on Friday. I look really sloppy right now, but I recorded a bunch of them today, and I'll get those out soon. So we got some really nice. I always like somebody says nice things to me. That's cool. Very, very good. Okay, cool. Happy to talk to you about your case, but yeah. Get some videos out there, but I want you to be aware of those when they come out. And again, I'm here to answer questions for you every Wednesday night. So everybody take care, have a good week, and enjoy the weather. Hope the weather is safe where you are. So we'll see you next week. Bye-bye.